Welcome to the courtroom where bloodlines meet deadlines. And this time, it's family versus family. A trust, a brother, a house, and decades of resentment. Forget TV drama. This one's real, and it's about to get messy.
Daryl West, from a property he claims is his home for life. Attorney Mark Lando represents the trust seeking to sell the asset, while West, representing himself, drops bombshells, an ongoing Court of Appeals case, number 37500, allegations of fraudulent court filings, and a claimed lifetime right to live there. But Judge Michelle Evans isn't buying it. She warns West his arguments are irrelevant, setting up a brutal clash over property rights versus legal procedure. With West revealing he's an amputee and alleging $25,000 in personal repairs, this isn't just an eviction, it's a raw family implosion with life-altering stakes. Who deserves the house? Let's dissect the drama.
Court does call the case, Westborne Family Trust versus Daryl West.
Mark Lando on behalf of plaintiff.
Mr. West, state your appearance.
Daryl West present.
Okay, where are we on this case? I'm afraid to ask.
Judge, this is a termination of tenancy act.
When a judge says, "I'm afraid to ask," you know it's not a good sign. What should have been a routine property case just turned into a soap opera wrapped in legal jargon. And here's the kicker, in trust law, family doesn't automatically mean ownership. That's about to become West's biggest problem.
My client is the owner of property. Mr. West is the trustee and the trustee's brother. He's been living there a lot of years, and they are estranged. And my client just wants to get the property back, sell it, and that's pretty much the long and short of it.
It's not the long and short of
All
it.
right. Well, I've read everything that you submitted, Mr. West, much of it irrelevant to these proceedings, quite frankly. The only thing that I have that may be of some relevance, is there a matter pending in the Court of Appeals?
Yep.
Immediate tension. The plaintiff's attorney frames this as a cold business decision. The trust wants the property sold. But West's presence hints this is deeply personal. Legally, termination of tenancy actions are usually straightforward, but family dynamics change everything. The judge's "I'm afraid to ask" foreshadows chaos. Key legal point, being the trustee's brother grants zero automatic rights. Trust assets belong to beneficiaries, not family. West must prove a legal interest beyond blood ties. The attorney's blunt long and short of it downplays the human drama about to explode. Would you evict a sibling?
Absolutely. Case number 375000.
Your Honor, Mr. West filed a motion to stay the eviction case that was denied.
That's not exactly
in the Court
correct.
Of Appeals?
It was denied with the Court of Appeals.
All right, thank you.
Judge, that's not exactly correct. It's a misleading statement. Actually, what happened was filed an interlocutory appeal, and the circuit court went ahead and ruled while that interlocutory appeal was pending. Therefore,
Procedural minefield.
Here's where most people get lost. West is basically arguing that his appeal should have frozen this eviction. But unless the higher court formally stays the case, it keeps moving. No paperwork, no pause. Would you gamble your home on a technical appeal like that?
References case number 37500, likely an appeal of a related circuit court ruling. Plaintiff's attorney claims a stay was denied, but West counters it's an interlocutory appeal dismissed on technical grounds. This is critical. If West's appeal challenged the trust's ownership or his occupancy rights, it could impact this eviction. But the judge shuts it down hard. No stay? No delay. Legally, she's correct absent a binding order. Yet West's insistence suggests he believes the appeal invalidates this case. Is this procedural ignorance or a legitimate grievance? The judge's impatience is palpable.
I filed a right of appeal and let the interlocutory appeal be dismissed. And it was on that basis that the interlocutory appeal was dismissed based on the current pending case. And there's still on the docket a motion.
But there is no stay of these proceedings.
There is a motion for stay of these proceedings on the 375000 case.
All right. Well, you're going to have to get to them because I don't see here that I've got a tribal issue. I am not going to stay these proceedings. And so if the Court of Appeals wishes to stay it, then the Court of Appeals can stay it. Mr. Landau has indicated that they denied it. You're indicating something different.
Am I entitled to a jury trial?
If I don't have a tribal issue, no, sir.
Judge, there's promissory estoppel, there's quantum meute, there's a...
This is painful to watch. West is fighting with heart, not strategy. He's tossing legal buzzwords like promissory estoppel and quantum meute. But without filings, they mean nothing here. It's like showing up to a sword fight with a dictionary.
A written, documented contract, documented and subscribed by the plaintiff.
The heart of the case. West drops his nuclear claim, a lifetime occupancy agreement signed by the plaintiff. If proven, this could be an equitable life estate, a legal right to live there until death. But the judge finds no such document in evidence. This is devastating. Without filing proof in this case, his claim is just an allegation. Legally, he must formally assert this interest via a counterclaim or separate action for the court to consider it. The judge's directive, file paperwork in circuit court, highlights a fatal self-rep mistake, failing to properly plead his defense. His strongest argument dies on a technicality.
All of those are not tribal issues that grant you possession of the premises, sir.
The document subscribed by the plaintiff grants me premises occupancy.
I disagree. It's not a tribal issue for me, sir. You show me nothing that gives you claim to those premises.
I submitted the document where the owner of the property granted me living arrangements to the property. That's in the file.
For how long, sir?
For the balance of my life.
I do not see anything in here representing a life estate. If you are claiming that you have a life estate, then you need to file the appropriate paperwork.
It's not a life estate, Judge.
You need to file the appropriate paperwork in the circuit court so the circuit court can make a determination as to whether or not you have a life estate of some type on the premises. But I do not see that. I do not see any defect in the notice which has been provided by the plaintiff in this case. I have nothing to try.
Please address their complaint. Their complaint clearly files misleading information. In item 2, counsel says there is no other pending or previously filed document or court actions. And in fact, there was a circuit court action and it's under appeal now. Therefore, that's misleading statement. Furthermore, in
Scorched earth allegations. West accuses the trust.
And there it is, the perjury bombshell. West accuses the trust of lying in court filings. Sounds explosive, right? But legally, it's a dud. Unless he proves it with hard evidence and ties it directly to possession, the judge won't care. This court's about who owns the house today, not who lied yesterday.
To perjury in the eviction filing, 1. Denying pending litigation, while case number 37500 exists, and 2. Claiming property maintenance compliance. He reveals the trustee admitted under oath in another case to zero contact in 10 years, contradicting the maintenance claim. This is legally explosive. Knowingly false pleadings can lead to sanctions or dismissal. But the judge dismisses its relevance to possession. Here's why: even if true, it doesn't negate the notice to quit or prove his right to stay. His remedy? Sue for fraud separately. A brutal legal reality check.
Which has no relevance to this court and its decision, because this case would not have gone up to circuit court.
This case was already in the circuit court on a parallel.
No, sir. This case is a district court case. This case, regardless of what plaintiff said, would have been filed and resided right here before me.
Judge, can I go on further to the complaint?
Not if you're going to waste my time.
I'm not.
Yes, you are, but go ahead.
In Section 8, plaintiff and counsel suggest to this court that the property owner has maintained that property in accordance with state law as it's a residential unit. That is absolutely a false statement. She has stated in a statement of facts and a motion at the circuit court that she hasn't communicated or been in contact with the resident occupant, Daryl West, in 10 years. She has not maintained the property in accordance with Michigan law. Furthermore, because I had to maintain
the $25,000 gambit. West claims he invested heavily in repairs, implying unjust enrichment or a constructive trust. Legally, this could create an offsetting claim, but not a defense to eviction. Quantum Marut, payment for services, requires proof the owner requested the work. Without that, it's just a voluntary expense. The judge's silence here speaks volumes. Unreimbursed repairs don't grant possession rights. Worse, it undermines his lifetime agreement claim. Why pay $25,000 if you own it? This emotional plea backfires, painting him as financially entangled but legally unprotected.
I spent $25,000 of my money to keep the property maintained. She has completely falsified the complaint, Judge. She did not provide adequate maintenance to the home in reference to Section 8 of the complaint. That's a false statement. There's two false statements provided in the complaint, and the court should order a show cause hearing at the very least and should actually dismiss this case.
Are you done?
Yes.
It still is not an issue related to the termination case. If you believe that there's a money case that needs to be filed, then you may do so.
Judge, one last point.
I thought you were done.
I was until you made that comment.
Sir, I might suggest that you get yourself an
Judicial warning shot. The judge's advice to hire counsel isn't.
This is the heartbreak of self-representation. You can be 100% passionate and still lose 100% of the case. West isn't just losing his home. He's learning that in law, emotion doesn't move the gavel. Evidence does. Ever seen a judge sound sympathetic yet completely done? That's this moment.
Kindness, it's frustration with West's procedural missteps. He's arguing equities, fairness, in a summary proceeding focused only on legal possession. An attorney would have 1. Formally asserted the life estate claim, 2. Moved to stay based on the appeal, 3. Filed a counterclaim for the $25,000. Instead, West wasted his hearing on legally irrelevant arguments. The judge's "I've let you go longer than normal" confirms he's losing credibility. This is the self-rep trap. Passion without strategy equals certain loss.
attorney to represent you.
Can you adjourn it?
Because the termination case, nothing has been filed before me that gives me anything to try as a reference to termination case. I'm going to keep saying it. There's nothing that you're saying to me right now. I've let you go on far longer than I would normally let anybody else go on regarding this. If you have one more thing to say to me, you may, and then I'm going to have my word.
Have your word, Judge.
Court finds that there's no tribal issue as to the issue of possession in this matter. I will grant judgment to the plaintiff for possession with a writ to issue in 10 days.
Wow.
From the signing of the order.
Judge, as much as I appreciate the court making that ruling, I'm willing to give Mr. West additional time. My client is his sister, and even though they're estranged, she knows that this is going to create a hardship for him. He is an amputee, and it's going to take him some time to vacate. I want to give him the comfort of some additional time.
So here's what I'm going to do, Mr. Landau. I understand that. So I'm going to issue my judgment. What the parties work out, you can work out. But I'm going to issue the judgment as I pronounced it.
Very good.
Thank you.
I'll submit the judgment.
The verdict? A masterclass in procedural rigor versus emotional claims. The judge granted possession to the Westborne Trust because Daryl West failed to prove any legal defense to eviction. His lifetime occupancy claim lacked documented proof filed in this case. The pending appeal, number 37500, had no active stay halting proceedings. Allegations of fraudulent pleadings required a separate action, not dismissal. His $25,000 in repairs didn't establish possession rights. The plaintiff's offer of extra time, citing West's amputation, was strategic grace, not legal concession. Court takeaway: courts rule on evidence, not hardship. Without proper documentation and procedure, even compelling stories lose. Fire: was West wronged, or did he squander his chance? Should family evictions have special rules? Sound OFF below. If this breakdown of legal hardball gripped you, smash like, share with Real Estate Pros, and
So, what do you think? Was justice served? Or did legal procedure crush compassion? Drop your verdict in the comments. And if you love dissecting real-life courtroom chaos, hit subscribe, because in these walls, every word can cost you everything.